Hello, fellow seekers. It's Darrell and me, Sally the Seeker, bringing you another day at the circus with Darrell. Before I begin, I got to vent a little to you. I got to give a little rant. So I was starting this video last night, and I got into about 35 minutes of recording it. And what I'll do usually at that point is take what I have and transfer the information into my computer. Well, when I went to transfer it, nothing showed up. It had disappeared. I know I had recorded it. It was so frustrating. I kept looking and digging. Did I delete it? Well, if I deleted it, it would have been in the trash. But I'm sure I didn't, but I could not find it anywhere. But that space of time was there. So I can only come to one conclusion. Well, maybe two. One, maybe I really did delete it. Two, I believe there's some paranormal activity going on here. Now, on the side, my daughter and I like to do a little paranormal. We're not investigators. We're open-minded, but we don't take it seriously. But there is a little bit of belief there. But we have our little spirit talkers and some other devices, and we'll go out to certain places or certain places that have been deemed haunted and that kind of stuff. And it's just something to do to get out, and it's fun. And, sometimes we do come up with some interesting stuff. But again, don't take it too seriously. But now I'm sitting there thinking, did one of those spirits, do they have that part of the video and they're doing something with it? I don't know. Probably not. But anyhow, yeah, this should have been out last night, so I'm sorry for that. And whoever took it, perhaps you could apologize too. Anyhow, so we are where we left off is Attorney Opper giving her closing argument. And of course, Darrell had to be put into the timeout room because he was being an ass and interrupting. And so, of course, now they have retrieved him and he's back into the regular courtroom. But you already know, well, since I saw 35 minutes of it last night and I'd seen part of it before, we already know, because all he's been talking about is jury nullification. So I'm sure they're going to have a big to-do about that for a while, but then finally he'll give his ridiculous closing argument. In the meantime, it looks like I really am averaging about one video a week, but, that's as good as I can do. We're almost done with school, a little less than 2 weeks. Hopefully that will give me more time. I mean, I have stuff to do over the summer, but I will be a little bit more flexible in how I can do this. So I'm happy to do that. And of course, I will continue with Darrell. And those of you who've been watching the Hannah Payne trial, thank you. It really is an interesting case. And you're going to get mad. You'll get, really, the big entertainment is the defense attorney. Attorney Tucker, I think it is. I can't remember because I call him Attorney Smarmy. But if you haven't watched it, check it out. Now, I have it on my playlist. I have the Hannah Payne trial in order, up to date. So, check it out. And also, I'm almost done with Hannah Payne. Once I finish her, I'm going to be getting back into the Apple River trial, which is very complex, controversial, and very divided. So, but also very interesting. So I'm going to begin posting on that because that had been requested. And of course, we still got Sarah Boone back in the corridors, and of course, Chad Dorman. His trial ain't going to be for a while yet, but there'll probably be some more updates on him. And also the Ferreters. I believe that I had made a video giving you an update on them, and it'll probably be a little late, but not late for as far as the time, because they've moved Tracy Ferreter's trial, I believe, to July. Ooh, that's in a few months, because I believe it was initially going to be March 18th. And like I said, I made it a while back, but it'll still have pertinent information for her and a little bit about husband Timothy. So that will be another interesting trial to follow if y'all haven't followed that. So I know, I'm sorry I went on, but since most of y'all watched Darrell, I just want to give you a little update on the other cases that are going to be coming forth soon. So now, without further ado, let's see what this clown is going to do. He looks so intent. Here we go. Why is he talking to the... I thought he wasn't really supposed to be communicating with the bailiffs. I mean, I guess they can communicate a little bit, but... blah.
The record should reflect that Mr. Brooks is now present in the main courtroom.
Oh, joy.
Prior to reopening following the break, I did invite him back into the courtroom, and he is here. I trust you are ready with your closing argument, sir.
I'm ready to address subject matter jurisdiction as well, too.
Oh,
the request is...
You know what? I know I have to stop so early, but come on, subject matter jurisdiction. Come on, there's nothing to discuss. She's given 2 written papers to him, the last one which he tore up, and he doesn't take the documents they provide him very seriously. He either leaves them wherever he is or places them in the trash or on the floor, and he wants them time-stamped and original copies and all that stuff, and it's like, come on, Darrell, let's just get on with it and get you under the prison for your 1,000 years, which of course he already is. But let's let him continue.
Denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Please, don't lie. Look at her face. You know that they have given him his copies multiple times. I bet Madam Clerk was so done with him. And you can even tell with Judge Darrell, because we're reaching the end, and she is like, he's on her last good nerve. And she is, I do see her, I'd still do things a little different, but she is starting to nip it in the bud a little bit sooner. I might regret what I said in a minute, but okay, here we go.
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There's no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of your, you said written decision?
She's done that 2 times.
My written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, I don't have it.
Lies.
As a courtesy, I'll have my clerk print off a copy and provide that to
okay,
you.
I disagree. No, you stumbled there, Judge Darrell. I will not do any more courtesies for this idiot. He deserves no courtesies.
Is it proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
Nobody wants to know about it.
I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I
defendant.
accept for value and return for value this document.
I'm so glad you do.
Based in lawful law.
Oh, you don't even know what lawful law
And it does
is.
not prove subject matter jurisdiction whatsoever.
Have you even read
It
it?
refers to some complaint
Look at her. She's
that was
like,
filed in the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you aware
Please
of
be
that?
prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
All right.
oh,
So
come
that
on.
is a tacit agreement.
Oh, Lord. Here we go.
Record to reflect the jury is coming out. Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
Great.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed
Oh,
of that, Your
good. I'm
Honor,
glad she
but
started it.
I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why the jury deserves to
Mr. Brooks,
need to know.
this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30 plus pages to read.
Did you
They
inform
will
the
be
jury?
informed of the law.
Did you inform them that they
Mr.
can nullify the law?
Here we
Mr.
go.
Brooks,
Nullify, nullify,
You do
nullify.
not have that right to request that. And
Were
I'm
they
advising
informed?
you one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
They
Brooks,
are-
you
they
have no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
All right, I'm going to excuse the jury.
They should
Oh
know
my
that they have the
God.
power.
Please rise for the jury.
Now, just curious. Here they go again. One question is, how does he think the jury is really going to be on his side? And him talking to them about nullifying. I mean, I recall, and I think I've said it before, that the walk in between the courtrooms and where they go, it's a pretty long walk. I would be already, this is why I wouldn't be good on a jury. I would already be so pissed. I'd be saying, he's guilty. Let's just get done with it. As many times as he has put out everyone. But he thinks he's the only one, of course. But could she not go on? I mean, or would she have to? I guess the jury's out now, but couldn't she just say, okay, if you're saying you're gonna do it, I guess though it could go to appeal, I suppose. But couldn't she just say that he has forfeited his right to give his closing statement if he's going to not abide by what she's saying? I mean, because his argument is that they have the power to nullify. Yes. Excuse me. She already said they did. But it is still very improper for him to do that. He thinks his rights, there's the law's definition of a person's rights, and then there's Darrell Brooks and the sovereign citizen fools. Their rights is whatever they say goes. He just thinks anything is his right, but No, he always says his rights have been trampled on and all of this kind of stuff. And even the judge said, how did you say it? It's not unfettered, meaning that, yes, of course you have your rights, but that doesn't mean that everything applies. There are certain things that don't apply. But he just thinks, because he thinks it and he said it, that it applies. I know I'm going on, but, it was nice to see that Darrell, I posted a week or so back, looking kind of calm, but let's face it, he was in a wheelchair. And I know from you all and others that, and I don't know if it was before he went to the god-awful prison where he seems to be, I guess, happy now, but that he was doing all kinds of stuff, throwing his feces around. I need to get hold of that and look at that. And I'm sure he was horrible. So he probably was just playing an act that day when we saw him the other day, looking decent and everything. I mean, for him, but, and actually letting an attorney speak for him, but still. And by the way, I have not responded to your comments. I think maybe the last 2 videos or maybe the last one, and I apologize. I will be getting to that. I am a woman of my word, I believe, most of the time. I try to be anyhow. So I have not forgotten that. I just wanted to try to get this video up. So I know I'm blathering a bit, but hey, that's why I'm a commentator. So those of you all, who come on and don't understand, that's what this is. Okay. We will continue, because this is going to go back and forth for a little while. What is he sitting all... Look how foolish he looks. Why is he all positioned straight up like that? He looks like an idiot. Is he trying to suppress gas that might be coming out of him, or what is he doing? Does he think he looks honorable to the jury? I mean, I know they're gone now, but... I mean, like, even this fellow. I wonder what these people in the courtroom... he's probably a family member of a victim, or maybe a friend, or just an interested person.
Thank you. Please be seated.
Oh, my gosh.
Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bjerkas case, Bjerkass, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice.
Well, you know what? You need to shut up and let her forfeit you, because you're ridiculous.
Coerce me into a constitutional right waiver when I have not waived the constitutional right.
Well, she's going to waive it for you if you don't.
As a public servant.
Blah, blah, blah.
I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that
same questions, same dumb questions.
Denying me a constitutional right?
No, she's not doing that.
I haven't made such a determination as of yet, but you can forfeit your constitutional rights
under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to
Lord.
rights.
What do you even know about these things?
Versus Anthony,
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none of those that you just named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument.
Same difference.
So how's that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are two examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right
Shut up and listen.
A closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
I was denied the right to.
I'm not prepared to make that ruling here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays. I will not be taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
That's
arguments.
right.
Made that while violating my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
You have not been
once.
violated.
So
Come
let's
on.
make that correct. Once.
That's the third time.
Okay, now you can say
So, Mr. Brooks,
Such an ass.
I'm advising you yet again. The
I
time
don't
has now
consent to
come.
being called
That's
that
another
name, Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You were brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be told, informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
It's
you
not
are
trying
going
to
to
give.
let me ask you a
No,
question.
hello. I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
Yeah, it
That's
is.
why I'm asking you.
No, it
I
is.
don't understand that question because
Yes,
that's
you
not
do.
what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the. You just said on the record that they have the power.
Sir, I direct your
You
attention
just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury,
instruct them.
the jury
on
has
that.
the power
No.
but not the right to nullify.
Right.
A
You said
party-
the power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you are
telling you no
going
such
to
thing. I
disregard
just told you what you just said.
my directive to
No,
you to not
no.
raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir,
That doesn't
State
mean-
versus B. Jerkus says,
Oh, God. Now
and
we have to do this.
stands for the proposition that although the jury has the power of jury nullification,
They have the power.
no
The
party has
power.
the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed.
the
I just
You're
want them
misunderstanding the word
That's
argue,
it.
you idiot.
informing, making them aware.
Yeah,
Whether
they should be aware
you
of
are
the
not
right.
allowed to make them aware of their power to nullify.
How
That is
can I not
an
make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that is
not
not a
inform
right
them of a
that
power
you
that they
have,
have? I'm not giving a new jury instruction.
That is
That's not
because
what I'm
there is
arguing.
no jury instruction for jury nullification,
Yeah, I'm
sir,
not- I'm
because
not-
it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification
I'm going
before
to
this jury.
inform them of the power that they have. I'm not
You are
giving them.
telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
on telling them
Nobody's talking about jury
nullification.
instruction, idiot.
That's what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying.
No.
You just read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They are not to be instructed on it. That is very clear in the law. In
Your
addition to, no, let me finish. In addition to the case that I just cited, I cite to you from the jury instructions, the law note on jury nullification 705. What that says, sir, is I'm not going to read it all. It's many, many pages. But the bottom line is, it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork because
I'm
brought
sure
that
that
up.
is
So
not
you never
why,
intended for this
you
to even
fool.
be an
No.
issue.
Mr.
It
Brooks,
never was brought up.
if you
But
think
then
I
when I
wasn't-
raised the issue,
If
Your
you
Honor, let
think
me
that
finish.
I'm not prepared to deal with an argument on jury
I
nullification,
didn't say that's not what I said. That's
You are
not what I
missing
said.
the
In
mark.
all fairness, that's not
He
what
sure
I
is
said.
missing the
the
mark,
record
big
should
time.
accurately reflect that you were kept in that holding cell
Why was I kept
so
in there?
that my clerk could finish
Adding a jury instruction that was not there.
76
Oh my gosh, could he stop interrupting her and let her finish? And I'm interrupting too, I know, but I can do that because I'm reacting. And I'm reacting vehement. I can't even talk. I can't say the word vehemently like he says it, I vehemently. Oh my gosh. Yep, we're back to the old Darrell. I mean, Darrell never changed, anyhow. He can look good. He can act good when he wants to, but most of the time he doesn't. He doesn't get it. He thinks that he had to be held up in the cell. He acts like he's such a VIP because she was just going to add that one thing. That is not. He is so delusional. Delusional Darrell.
forms, and it's times 2 because there's a guilty and a not guilty for each. No,
Quit
let me finish.
interrupting
So how
her.
did I have? Why did I have to sit here for that? Where I could have just went to my cell and had it delivered.
What are you at Holiday Express or something?
We had this
Mr.
at the
Brooks.
end of last night before you called recess.
I'm not going to debate
We had a
that
whole
topic with you further.
conversation about
Mr. Brooks, you are.
She doesn't have to tell him anything about why he was there or when she was delivering stuff or what she was doing. He just needs to sit in there and shut up. Oh, look at her. She's right now about, if you look closely, there's steam coming out of her ears and her nose.
bringing up about the jury
Defiantly.
nullification.
Disregarding this court. You
Here we
you
go
can
with this.
roll your eyes
Here
at
we-
me
because
all you want.
It's ridiculous, Your Honor.
No, you're ridiculous.
You just stated that they have the power to nullify
No.
Would you
any
like,
law,
if you would like,
but then
I
I
will
said-
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom.
I think you should
But
remove him.
that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
Under what lawful law?
Under State
Oh my
versus Anthony.
gosh.
It doesn't refer to that.
State
You don't
versus
even know.
Anthony may not have dealt with
It hasn't dealt with
the
closing
right
arguments.
to a closing
Don't act.
argument, sir.
She knows
but
this
the
more than you.
You just said it right there.
nonetheless is
No.
fully applicable.
No, you
because the more
can't
general
change the law, Your
principle-
Honor. You can't change the law.
Oh my God, who's changing the law? Her or him? Look, even our typically well-composed bailiff looks like he wants to knock his block off. I'm telling you. I know he didn't, but he could go on and do it. All of us would turn our heads. Nobody would say anything. It would be justifiable. I wish he would do it. I wish he did it. Okay, here we go.
Law that's
I'm
practiced
not
in law from
changing
the
the law,
bench.
sir, but the general
Oh,
I know
principle.
you used to be in legislation, but you can't practice law from the bench.
Don't throw those things
I'm
out.
not
You can't do that.
practicing law from the bench.
You are if you're changing. Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect?
I will,
to
Your
do
Honor.
that?
I will.
All right.
How long?
So, looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights, waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there, I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct
He's not even listening to her.
assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling
He's not going to do that.
Then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor.
Oh, would have been. Oh, look who's in the house. His buddy behind him. Jay Prince for president. His only friend. Or is he?
Object to that ruling.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power.
God.
Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to
He really
being
doesn't get it.
for the proceedings of trial and for testifying.
Sir,
Not
what
one
I'm
time
telling
did you.
you,
Hold on, I'll let Your Honor, with all due respect, I'll let you make your record.
I would
think
tell
that
him,
it's
no,
right.
we're done.
go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have, how is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I just cited, sir, I'd also point you to State versus Bajirkas, 163 Wisconsin 2nd at 549. That's a Court of Appeals case from 1990.
Well, you know what? If you would raise such a big stink over it, she wouldn't have to go over a lot of stuff for you. You're a lot of trouble.
That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions in the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now. I'm the only one that has to be made rules for closing argument.
He had to take off his mask. Why? My insides are just curling up. Why do we have to see his whole mug?
Mitch, but not the prosecution. How is that fair? How's that balanced?
Because, fair. It's not fair. It's not balanced. And you're not balanced either. Because the prosecution has studied years. They have experience. They know what they can do and what they can't. It's that simple. I don't know why he thinks he's so above all of this.
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification
It's
that
not
is
defiance.
requiring
It is.
to
Yes,
address
it is.
this issue and to tell you very
Your Honor,
expressly
I
that is the rule.
Oh, you're
I
good. Vehemently, there he goes.
vehemently object to that.
Nobody
Your objection
cares.
is noted for the record, but
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
No.
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling.
So, who cares?
For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
All of those requests are noted. I will not reconsider.
Denied.
I have put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
No.
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your
to
Honor,
a court of
because-
appeals, not this court.
No, this is. I'm supposed to be in this admiralty court.
Oh, gosh, here we go.
If we're under Article 3, then we should be in common law court. That hasn't even been addressed. If we're in a common law court or an admiralty court.
Oh, my God, you're so stupid.
That's a baseless argument, sir. I don't.
And
So
what law and
baseless.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
an
informed.
opportunity
I'm informed of that.
to present a closing argument.
Yeah,
if
but
you
you're
violate,
also, you're
please
also,
let me,
but
sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
Shut
You
up.
just tried to put me under a rule that no one else was put under.
The circumstances
Nobody else is trying to tell the jury they can nullify. Oh my gosh.
require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't, Your
on
Honor.
the issue
That's a
of jury
prejudice to my
nullification.
defense. You
No,
can't
it's
place
not.
me under certain rules and not place the prosecution under
The
the same
prosecution
rules.
has done
The
it properly.
circumstances of this case and your insistence on arguing jury nullification has resulted in this court creating this rule.
I haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them the jury instruction.
It is
You may
considered
not
an
advise
argument,
them
you
or make
fool.
them aware in any way that they have the power.
And why not?
Jury
Why can't they be
nullification.
informed of their power?
Because it would
Why?
violate
She's
the
told him
decision,
multiple
sir.
times.
Violate what decision?
All right, sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present a closing argument
Under what
has
lawful
been
law?
forfeited based upon
And I make a
how
oral,
I've outlined that
oral
to
motion
date.
for
I'm
legal
not going to
finding of
declare
fact.
that at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't do
to
that.
Oh, yes,
present
she
a closing
can.
Under what
argument.
lawful law can you?
And then if you continue
You
to
know
interrupt
what?
What
me,
lawful law?
you will be removed to the other courtroom as I complete
So I'm being
the
held in contempt
instructions.
again. Is it civil or criminal?
All right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant, in his petulance, will say jury nullification in the first 3 seconds the jury's in the room.
Yeah, she's right about that.
Objection to that.
Oh, shut up.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop
to.
interrupting
I don't
Attorney
think I
Opper,
should be
please.
talked down to.
She's not talking
Allow
down to
make his
him. He's
closing
such an idiot.
argument. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
She's right about that. That's why I love Sue Opper.
I'm certainly willing to try that.
It's about all we can come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and then if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Agreed.
Your Honor, I object to that.
I'm sure you do. You can object all day, but it's still going to
Your
happen.
objection is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in blatant disregard of the requirement that you not reference in any way during nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
You can object, but she's
All
still
right, with
going to
that,
do
let's
it.
bring the jury
For the
out.
record, may I respectfully request the legal reconsideration
No,
of
just
your
stand
ruling?
up. It's time. He just is still trying to delay, stall. But you know what? It's getting closer to going under that prison. Thank God, right? Okay.
So is that a tacit agreement that you don't have to answer my objection, Your Honor?
Put your damn mask back on.
I
Ugh.
decline to reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
Denied.
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
Denied.
I'm not the court to address that.
That's right.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Denied.
Under,
The jury
based
is
on
coming
what
in.
law or
All
fact?
rise for the jury, please.
Based on what law or fact?
Just shut up and give your stupid closing argument.
Because I'm going to inform the jury of their power. They deserve to know.
I bet they can hardly wait. He looks so pompous and arrogant, doesn't he? Trust me, I'm sure the jury is and was not impressed by him at all.
Thank you, everyone. Please be seated. Go ahead, Mr. Brooks, your closing argument, please.
God, he's gonna do it without his
Good
mask.
afternoon. It's been a long day. First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe.
God.
And one thing that I believe that you have not been privy to is the truth of your rights and your duties, being the jury. The fact that you and you alone have the power.
Oh, Lord.
Not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics.
Can I just say, no, sir. You were the one with a lot of theatrics, not the prosecution.
Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth.
And they have the power to put your ass into prison for 1,000 years.
You should be informed that
Look at Sue.
you
She's
have
ready.
the power to nullify any law that you don't agree with.
Objection, move to strike the statement.
Sustained.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's
Fair.
essential that you be privy to all knowledge. Not knowledge that certain people feel that you should hear and shouldn't hear. Disguised under the color of law.
What? And disguised under the color of law. I bet he rehearsed that for hours, even though he said he didn't rehearse anything. Disguised under the color of law. Okay, proceed, idiot.
The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech.
Well, of course not. You're a felon.
I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart.
Oh, how do you know they stood in front of a mirror?
In my opening statements, and now I'm going to speak from the heart.
I mean, we can tell. Trust me, we can tell.
What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event. It should be recognized.
Yeah, the attack you caused.
Trying to argue facts of this, facts of that. I'm not going to waste your time doing that.
You're not going to talk about how you ran over all those people?
It's a little emotional. I apologize for the long pause.
Nobody cares. We would prefer the long pause.
It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left.
You didn't have any to begin with.
For the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone. What you've been hearing from the prosecution, and not to take anything away from them, but
you won't. Don't worry.
Let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it. But they play it so much that eventually you start saying the words to yourself before you even realize it.
You mean the over and over again, like subject matter, jurisdiction, sustain, is this lawful law? That kind of record? Because you're the one who's really been doing the broken record shit. Just saying.
And then you sit and you go, I hate that song. Why am I singing? That's what's been happening. Rerun. Over and over and over and over and over and over and over.
Yep.
Attempting to make things stick in your head that simply aren't true.
Kind of like you are?
Why do I say? What am I saying? I say, look at the testimony. You know, the theme from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do?
I don't think they have to look inside their head. They can watch the idiot that prior to going to the parade to cause the attack nearly injured his ex-girlfriend again, and then went down the wrong way to the road, on the road by the gas station, where, and was angry when he was in the wrong at two people who ended up, by the way, to be witnesses at the attack. So, and then so angry you could not be stopped. What were some of the things? He looked like he enjoyed what he was doing. He could have stopped after the first or the second one, but he didn't. He just plowed forward. So it's not anything about what's in your head. How about just what you did? Never mind what's in your head. We know there's craziness in there, but your actions are what determined this.
You know, for a year, I've sat and gone through this. Feeling so powerless. You know, letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero.
Really? Zero truth? How about the helpless people that didn't know that they were going to be plowed over? And you continued to do it. Bump, bump, bump over children, families, older people, people from the Catholic community, the band members, the grannies, Jackson's team. You are a joke, sir.
I understand about healing myself, tragedy, pain, all that.
I doubt it.
A lot of it, there's no need to get into.
Yeah, please don't.
I myself in my own life have had to do a lot of healing.
Oh, well.
As a man with children myself.
That you have had nothing to do with.
I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act.
Well, where are those people who've spent time around you? Other than Jay Prince for president, and he hadn't even spent time around you. So the people, where are they? Where are these people that were going to be lined up sitting with you? Don't see anybody. That says a lot.
I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn.
Oh, Lord. Again. Oh, no, is he going to start to cry, get his tiny tissue? You know, that horn blowing thing, just because he honks his horn, does he think that means that people are supposed to get out of his way, and if they don't, that gives him a pass to run over them? So stupid.
While attempting to alert people of their presence.
Yeah, why didn't you stop? Why didn't you stop?
Which brings me to
Gonna...
more information that I believe that you should have been privy to.
Oh my God. But
and I'm sure that the prosecution will beg to differ. But the fact of the matter is...
Well, of course they will, because whatever it's going to say is going to be wrong.
The vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Oh, Lord.
Misstatement of the facts not in evidence.
Was in fact.
Yeah, exactly. They've already went through this over and over again. Attorney Basie did very well with that when she questioned the mechanic fellow. Just stop, Darrell.
It's the same.
Was in fact recalled.
No.
Was in fact a class action lawsuit against Ford for those model vehicles.
Sustained, the juror will disregard.
Information that you should have been privy to. That you weren't allowed to be.
That's not true. They were in court when Attorney Basie questioned the mechanic. Oh my gosh. You don't realize you're not dealing with idiots like yourself. They are very aware of what happened in all of your shenanigans.
Privy to.
Oh.
Why? I don't know. That information, malfunctioning throttle bodies.
Mr. Brooks, move on.
It's the information that you should have been privy to.
Move on.
Vehicles that malfunction and accelerate, not being able to be stopped.
Objection, that is...
It's information.
There's an objection. Hold on. Go ahead.
Move to strike statements by...
Sorry
Mr.
for the
Brooks.
interruption here.
Facts not in evidence, Your Honor, and it's a complete misstatement.
Sustained.
How is it a misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known.
Such a liar. Good gosh.
Information that was taken away from you.
Please.
Why? To prove a case?
I know, I'm interrupting a lot, but it's okay. At least I'm trying not to talk over them. Can you imagine how awful that had to have been for the families, the survivors, families, friends, to hear him say all of this stuff and look at how they even managed to behave themselves in court, and he can't do it, and he's the cause of all of this. What a disgusting piece of crap.
Information that you definitely should have been privy to.
I wonder if he's going to bring up the shock shackles. Nobody's going to give a damn about that. We know that they're not shock shackles, but nobody's going to feel sorry for him about that.
DA says the defendant has an utter disregard for human life. Utter
Agreed.
disregard for human life.
It's true. Utter disregard. Yep. So true.
Not realizing that they're talking about someone that has children.
That doesn't mean anything. Jay Prince just left, didn't he? Uh-oh.
Talking about someone that watched their children come out of the womb and be born into
Okay,
this
now
world
you're just getting
umbilical
vulgar.
cord.
That's disgusting. Not the
held
fact of a
before their
child being
mom
born.
did.
Aww. Won't let him cut any umbilical cord.
Moments that I'll never forget. And yet they say disregard, utter disregard for human life.
Utter disregard. That is so true.
They made reference to a rage.
We've all seen it.
As if they were, or if this particular DA was right there, standing right there. As if this DA is a psychiatrist. I say to myself, with rage, what do you mean rage?
You know, it's obviously we all know this, but just to hear him over and over, it still amazes me how he detests Attorney Opper, obviously. But it's because she's smarter and stronger than him, and she doesn't give him an inch. And he knows it. And that's why he's saying all of this. He makes it so personal, too. That's the other thing. I bet the jury thinks that's pretty hilarious.
How can you characterize that?
By your actions, idiot.
How can you have the audacity?
Audacity. Look at them all looking at him.
To diagnose what someone's brain is, where it's at, what it's thinking, why it thinks the way it does.
Actions. Actions, my man. Actions. Your actions is what showed us.
DA makes references to blocks of no one being injured, but then says it's intentional.
That's right.
You add that up with the supposed rage, the supposed intent to harm and kill.
Yep.
And it doesn't kick in until well within blocks.
Oh my God, could he stop with those hideous, disgusting facial expressions? Why the hell didn't he keep his mask on? I can't stand when he does that. Ugh. Okay.
And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why would someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn?
Please.
You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding.
But that's okay. It's kind of like, here, just wait. I'm just getting warmed up. These are like such stupid arguments he's coming up with.
So where does this rage kick in?
We saw it in court a lot, didn't we?
Insatiable intent to kill kick in.
After Erica didn't give you what you wanted.
They speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Please.
Objection, fact, not in evidence.
What if
Sustained.
the driver of the vehicle was unable to stop the vehicle?
No, you were enjoying yourself too much, remember? Everyone saw it. They know.
Because of that fact, what if the driver may have panicked?
Yeah. Nope, not buying it. Neither are they going
Does
to.
that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people?
Yes, it does. It's all there. Everyone saw you.
DA played Exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could?
I think you still did a pretty good job.
Target people, mow down people.
You did all of that. You did. Do you regret that you missed some?
Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. For her testimony about hearing loud crashes and things of that nature.
Oh my gosh.
The DA wants you to believe that this all came from people.
It did. Look at them.
Evidence doesn't support that.
Zach wants to beat his ass up.
So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either.
Yeah, and you should
The
not
fact
forget
that
that.
there was lives lost.
And who did that?
And
Whose
all
fault was
the
it?
emphasis has been put on the alleged defendant. And the people have been disregarded.
You're so funny. You're such a jerk.
Makes me wonder, does the DA even care about those people?
That's so lame. Look at her. Okay, so I think what's going to happen. I think Basie is going to hold him while Zach and Sue beat the hell out of him.
It's going up every day.
Aww.
It's been suffering on both sides.
We don't care about your suffering, honestly.
It's been threats, hate mail.
Wah.
Because of the narratives that's been put out there. The
No,
misconceptions that have been put out there.
no, it's because of your
The
actions.
lies that have been put out there.
Because of the actions and the photographs and the videos
Lies
and the proof.
that have caused my children not to be able to go to school.
Aw, that's
To
your
be
fault.
bullied.
That's your fault.
For my mother to have to leave her home and stay at a hotel because she's afraid for her safety.
Well, she should have thought about that
She
better when
is.
she raised you.
Hate mail shoved through her mailbox. My nieces and nephews to fear for their safety.
Yeah, because you almost shot one of them. You're such a joke.
And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time.
I guarantee you, baby girl don't want to talk to
Now
you.
Attempting to answer her questions that she's asking, and still continue to shield her from what she sees, what she hears.
Shielding
Having a
them.
newborn son that I haven't even been able to meet.
Whose fault is that?
Haven't been able to hold.
Oh God, here we go. The pretend tears.
Having to navigate everything that comes with this whole situation.
Yeah, you've had a lot of navigating to do. Bless your heart. You must be exhausted.
While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell. Especially during lights out, alone, where it's just you.
Yeah.
And just been praying and asking myself, how could this happen?
I think we all know how it happened.
Not just for the people but for everybody involved, the community too. How could this happen? How? The hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing.
Well, I think they've come up with plenty.
But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once.
You should have.
Because I know it wasn't. As a matter of fact, it never even crossed my mind to even attempt to ask myself that, because I know it wasn't. And I know sometimes during this trial probably doesn't show. May be hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine.
Nah, I don't believe it.
So again, I go back to all these exhibits.
You tried to work up all this time to try to squeeze a tear out. Exhibits, evidence.
Go back to everything that's been shown, everything that's been testified to.
Excuse me, guys. All the pictures, videos of you.
Everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements.
Mm-hmm.
I'm not reading from any paper, any books.
Not even your sovereign citizen notes.
Everything you've heard in opening statements, everything you're hearing now is from right here.
But there's no heart there.
Everything. You have the decision. You and you alone. All of you. You have the decision. I'm sure you've taken a lot of notes during this process.
Oh, yeah.
Some days are longer than others. A lot of movement in and out of the courtroom for various reasons.
Thanks to you.
Remember the power that you have.
God. Oh, they're not going to forget it, trust me.
Don't for 1 second let it be taken away from you.
Well, they won't. They'll do the right thing.
I can never understand the position of sitting on a jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made.
It will be.
The right decision.
It will be. Get done already, would you?
It's almost like that
Oh, God.
that message. Well, not message, but that writing. When we're in our vehicles and we have that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear.
But in this case, they are, for sure.
I can't speak for anyone else, but me, myself, I believe in Jesus Christ.
Oh, man.
Since I was raised, that's what I believe in.
Why don't you walk the walk? You're talking the talk, but you're not walking the walk.
None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom,
Oh,
I
please
have
don't
my
hold it
Bible
up.
with me
Oh,
everywhere
God.
I go.
Look, you didn't have to say that. People saw it.
I even read it on breaks,
So
recesses.
cringe.
This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb.
You be talking about the womb. It's really making me uncomfortable.
This is how my family lives their life. This is how we was raised.
Well, reading it is great, but if you don't live it, it doesn't make any difference. Oh, God. Here we go. Did we ever muster up a tear here?
For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear.
Oh, God. Really? That's not going to win any votes for you, dude.
And because I believe, I trust him with my life.
You and your clear conscience. Oh, God. This is so sickening.
Nobody will never know why it was his will for this to happen.
His will. Now he's going to put God. Now he's throwing God under the bus. No pun intended. Wow. That's going to really win them over.
A lot of lives were changed that day, mine included.
We don't really care about yours. That wasn't God, that was you.
God's way is not our own.
Phew.
And no matter how much sometimes we want to question, we have to have faith.
Hard to have faith when you're the one who did it. Could you wrap this up? Looking at the post-its on the ceiling again. There's nothing there for you.
Look inside yourself.
They don't have to.
Look inside yourself and make the right decision.
Don't you worry, they will. Sit down. Please. Oh, God.
Look inside your heart.
Mm-hmm. Are you done?
You have everything in your hands now.
Mm-hmm. Sure do. All the evidence, photographs of you. Oh.
Everything.
Mm-hmm. They do. Okay.
It was right.
Don't worry, they will. Now, you can sit down now. We've heard enough.
It was right.
Okay, they heard it the first time.
Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power.
That would be your theatrics, sir.
Each and every one of you has a decision.
Sure do.
Who's right?
They will.
Make the right decision.
Okay, they know, they get it. Quit being the broken record that you say the prosecution is. Sit down. Just hold him captive.
It's hard to think about.
Excuse me, guys.
My younger kids getting older and at some point having to explain everything to them.
You don't probably see them to explain it to them.
Kids don't stay kids forever. And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much. I got a letter the other day.
Oh, God.
My youngest daughter. And she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, Dad, and this is from the letter. She said, Dad, why are people saying all these mean things about you?
Because you're an evil animal. Yeah, she needs to know the truth.
I haven't read the rest of that letter yet.
Theatrics at its best. At its best. Okay. Well, maybe tonight when you're in your cell all by yourself, you can finish reading it.
The rest of that sentence said, that's not the dad I know.
Okay. Wouldn't normally say this, but hang on.
Throughout this year, I've been called a lot of things.
God. Monster. Asshole.
And to be fair, I am a lot of things. A murderer is not one of them.
I think most of us would disagree with that one.
Never has been, never will be.
No, we disagree. Okay, let's.
So before I close,
Please
my
close.
statements.
Mm-hmm.
I just want to say, open your hearts.
You've already said it.
Go inside yourself when making this decision.
Oh, Lordy.
Have no fear. Pray and do what you know is right.
Oh, they will. And don't you try to tell them what you think is right, because they know what's right.
What you know is right.
They will.
Think about everything you've heard. Think about everything you haven't been privileged to hear.
Mm-hmm. But look at what they saw and heard already.
Think about the whole entire picture.
Yeah, the whole entire picture of people being run over. And she's lying everywhere. People trying to resuscitate their loved ones. Or strangers doing it. That's what they're going to see.
And above everything, whatever you decide, make sure you yourself can live with it.
Oh, they'll be able to live with it. Just like you lived with your decision. They will live with theirs for sure.
Make sure you can live with it.
Oh, they can.
That's the magnitude of the power that you have. Just like this tissue is in my hand, this is...
Don't you see your snotty
everything.
tissue?
You have everything. Be at peace with what you decide.
And he's talking about theatrics.
Have no regrets.
They won't. You're delusional if you think
Don't
that...
let this decision weigh on you after it's over.
Oh, it won't. He's delusional enough to think that they would feel...
Hopefully we got a lot of living ahead of us. Lord willing. Don't look back and kick yourself in the behind.
They won't. What about your regrets? Do you have any regrets, Darrell? Look into your heart.
Spent about 3 weeks with you. Took a lot of courage and a lot of guts to pause your life for this.
Well, I know you don't know that, but they had to do it. It wasn't a choice.
To put important things on hold. to basically stop your life.
Yeah, that's exactly what they did.
You should be commended for being able to sit up here with this amount of pressure.
And all of your interruptions. And time wasting.
I want you guys to know that's not lost on me.
Aww.
I'm sure it's a lot. And you all should be commended because it took courage to do this.
Now here comes the butt kissing.
I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now.
You might be surprised.
And you guys had the guts to do it. Thank you for that. Thank you for taking pretty much a month and setting it to the side for this. I know it's probably not proper, but you guys deserve a round of applause if you could get one.
Oh, please. Please, please don't start anything. That is so... yeah. Makes me want to retch. Will you want to applause when they come back with the verdict?
Thank you guys, sincerely. And I know, and I have faith and I trust that you guys know what's right.
Oh, yes, they do.
Ladies and gentlemen, I don't think it's fair to just say guys, but
Now you're going to be all polite and such a butt kisser.
I believe in your heart you know what's right.
They do, so I don't know why you have to keep saying it. They do, trust me. They really do. Okay, good. Sit down. And thank you. Lord have mercy.
Thank you, sir.
Oh, no, he's going to act like he's wrong.
Before I give the state an opportunity to present rebuttal, please stand for a minute. So please stand.
Ugh, that tiny Kleenex. Oh, good, he's getting another one. Ugh.
All right, have a seat, please. And Attorney Opper, I did time both closings. You have 13:28 left.
Oh, okay, let's see.
Thank you, Judge. I don't think that'll be an issue.
Good, let's just hear her. How refreshing.
Folks, let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family, the Owen family,
Thank
the
you.
Duran family,
Yes, that's
the
right.
Hospital family, the Kulik family, Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones. I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed.
Ooh, you know he's
It's
going to be
known.
pissed with that.
You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir.
Ooh,
Your actions
yeah.
are that of a murderer.
Thank you.
You murdered these 6 people.
Chilling.
You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position.
Yeah, thank you.
If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Ooh, that was awesome. Awesome, Opper.
Objection.
Oh, Lord. He can't object. He doesn't like the way he was
Now, members of the
disrespected.
jury,
Yeah.
the duties of the parties and the
I
court
love
have
it.
been performed. The case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 76 forms of verdict will be submitted to you concerning the charges against the defendant, Darrell E. Brooks. Count 1. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged.
Okay, I decided to let her go and finish reading the counts, the charges. You know, there were like 76 of them. And now she's concluding and giving them their final instructions. So I figured I'd pick it up here because that's a lot of reading. So here we go.
Charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the parties before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdicts will be read into the record in open court. The court may ask each of you if you agree with the verdicts. Before I swear the officers, we will determine the alternates, and then I will have all of the civilian
I see sun's
bailiffs
trying to come through. I'm
and
trying to
deputy
prevent that from
bailiffs that will
hitting the
be
screen. Sorry, guys.
in charge of the jury during their deliberations and sequestration. Yeah, let's see. Okay.
He looks a little worried now, doesn't he? I'm trying to move this because of the sun, even though my curtains are drawn. It's trying to come through and... Sorry, guys. There we go. That might be a little bit better. I think he's sweating it now. Now, is he going to try to look all pitiful for the jury? I think it looks creepy the way he's looking at them, honestly.
So we have placed each one of your numbers in the tumbler. I'm going to draw 3 numbers. Those numbers will be the alternates, who will nonetheless be sequestered in the event we would need to call upon one of you to replace another juror. The first number that I'm pulling out is 10. The second number I am pulling out is 30. And the third number I am pulling out is 1. I want to confirm that I still have 12. I know Madam Clerk did it, but I will also do that to be sure. And I just confirmed that the other 12 numbers were in there. I'll put those back in and then we'll make a record of that. All right, then I will need all of the deputies
Excuse me.
and civilian bailiffs to come up and be sworn on the record for the sequestration, and I'll go ahead and do it. Oh, thank you. Clerk of Court Taj, why don't you join them just in case you're needed? All right, would you all please raise your right hand? Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or you speak to them yourself, except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God? All right, and then Madam Clerk will just make a record of who you all are. It will take us a moment just to have all the finalized paperwork to go back with the jury. I do have all of the verdict forms, if I want to give that to Jen.
That should have all the new ones in them. I wanted to make sure it does.
All right, and here are the jury instructions as well. For the record, it's 6:24. All rise for the jury as they're excused to begin their deliberations.
Look at him looking at them in a hopeful manner, it appears. Now you're going to unmask after being masked almost the whole time?
Do what she did previously.
But yeah, I'm gonna make all of them.
Looks like an
Yeah, no,
idiot.
I know.
Down and all
But
that
those are
stuff.
the,
Yeah.
is that closed?
No,
All right, thank you. You may be seated. Just so the record is clear, the alternates, of course, will not be participating in the deliberations. They will be in a separate jury deliberation room
You should have put that back on a long time
and
ago.
will only be called upon if needed, of course, after consultation with the parties. As far as how late, I will let them deliberate tonight. We have ordered dinner for them. I believe it will be here shortly. And I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner. Anything else the parties would want me to address at this
Oh,
moment?
I'm sure Brooks will have something.
From the state. Anything from you, sir?
Yep.
Yep.
So essentially, I'm gonna have to stay here while you're delivering. I'm gonna be able to go back to my unit, use the phone, shower.
Aw.
It is shower day for my pod. We only get 2 shower days.
I don't, so here's what could happen though, sir. I don't have a problem with you doing that, but they could have questions. And then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits, some exhibits initially. I wouldn't be surprised if we got that. So let me do this. Let me confer with the sheriff's department. I don't initially see an issue with that, but I want to make sure that they have a protocol in place and that's what they would like to do as well, okay?
And one more thing.
Go ahead.
I was curious. 61 charges for reckless. 61 injured parties did not testify. So how does that work?
Oh, man.
How
Do you really want to ask anything now?
essentially how are charges able to be charged if all of the injured parties did not testify?
From my perspective, sir, the state presented their theory of the case, and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law. And I guess that's all I can really say about it at this point.
I got a point though.
I'm sorry?
I got a point though.
I'm not going to comment on that, sir. Of course, the state bears the burden of proof.
Wait a minute.
And they have to-
What the heck is that creepy ass face? Here he is. His fate is in the hands of the jury, and he thinks he's all smart and clever and witty, and he just looks so freaking creepy right now. Oh my goodness.
convince a jury beyond a reasonable doubt. For better or for worse, sir, I was not presented with any motions to dismiss, either at the end of the state's case or the close of the evidence, regarding any legal arguments you may have had regarding those issues.
There you go.
And so at this point, the jury has the case, and they will determine their verdicts. If there are issues of law that you want to raise after the verdicts are received, then you'll have to make that determination.
Yeah, that has to be raised, because essentially you can't, if no injured party testifies, then it shouldn't be a charge.
I disagree with that characterization,
Oh,
sir, but
come
there is
on.
frankly no motion in front of me based in law or fact, so for me to comment
It's a little
any
late
further
for you
would
to come up with this, fool.
require me to give an advisory opinion, which I'm not willing to do.
So you saying I need to make a motion?
So what I will
Oh my
say at
gosh,
this point
he's so-
is I do have one issue that I would like to raise with the parties. I frankly would just,
It's
I need a
disgusting.
break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming. And I think it's reasonable. I need to put a few things together, but I do need to make a record of some information that I received earlier today, so that the parties are advised of that. But I will do that. Let me confer with the Sheriff's Department about your request. I'd like to take in about 30 minutes, address the issues that I need to address, or the issue. And I want to find out if that would interfere with your request about taking a shower and all of that. So if you can hold tight and stay with us for a little bit, that would be great. And I'll confer with the Sheriff's Department and have a more definitive answer for you shortly, okay?
Can I get my filings?
You want the originals back. If Madam Clerk has scanned them all in and they're uploaded, I don't have an issue giving you the originals back.
He's so
They will
odd.
have the date stamp. They don't have a time because they were filed in court.
When he put the time on, I also, so that you knew they were in there, printed them after I scanned them in, so it has a document number.
Like you're gonna, like he's really gonna go through his filings.
See, I didn't interrupt you. See,
I'm sorry?
I said, see, I didn't interrupt you.
He is
Thank you, I
so
appreciate that.
cringy.
Unless there's, I would like the
Ugh.
parties back in about a half an hour. Thank you, unless they have a question sooner.
Your Honor, do I have to go in that holding cell, or do I got to get to go?